Mary was a third-year nursing student at a major university. She was devoting all of her time and effort into becoming a nurse. She'd always wanted to do that. She didn't have a job, but she did have two kids, and she lived with her parents. Her parents were providing her with everything, not only a place to live, but food, clothing, gas for her car so she could get back and forth to school, and they were providing everything for the kids. The father of these two kids had done nothing. He only saw them about twice a month and didn't pay any child support. So Mary's parents came to her one time and said, look, you got to get this guy into court and get child support set. So she did. When they got to court, his lawyer argued that all of these things that Mary was getting from her parents had value and should be included in income for Mary for child support purposes. The court agreed, set Mary's income, even though she didn't have a job, at $3,500 a month, the value of all of those things she was getting. That meant that John, instead of paying $1,500 a month, was only having to pay about $800 a month in child support. Do you think that's the right decision? Can a court force a 16 or 17-year-old child to visit with the other parent? Well, that depends. You know, it's tough when a kid gets to about 15 years of age and there's a parenting plan in place that would give the other parent parenting time during the weekends. The reason why is because kids, when they hit 15, are usually in high school. They've got things going on. They've got friends they want to see. They've got places they want to go on the weekends that has nothing to do with either parent, really. So as a child reaches the age of majority, 18 years of age, it's difficult to force that child to do anything. And most good judges will tell you that. Judges hate parenting plans that would force a child to see the other parent on the weekends when that child is older. If you have a parenting plan in place and your kids are young, take advantage of that time, because as they get older, your time with them is going to be limited. I'm not saying don't obey the parenting plan. I'm just saying it gets tough. A couple came in to see me not too long ago, and they wanted to get divorced. They had everything worked out. They had written it all down. It was beautiful. They had divided up the property between themselves. They had divided up the parenting time, and they were going to get equal parenting time. Dad would have 1 week, mom would have 1 week. Well, here's the problem. They put 0 on the paperwork for child support. They had both agreed that neither one of them should pay child support to the other because, after all, they've got equal parenting days. Why should child support even be considered? Well, here's the problem. In Tennessee, as in most states, child support is not only based on the number of parenting days each parent has, but also the relative income. In this case, Dad was making almost twice what Mom was making. And in accordance with the guidelines, he should be paying Mom about $700 a month in child support. Kind of doesn't seem fair if they've got equal parenting time, but I explained to him the judge is not going to approve your parenting plan without child support in accordance with the guidelines. I was sitting in court the other day waiting for my case to be called, and the lawyer in front of me, it's a young lawyer, he had a case where the father of a 2-year-old child was trying to get custody of the child. Now, the problem that lawyer had with his client was that his client hadn't spent much time with the child since the child was born. It appeared that the mother and him lived together for maybe a short period of time after the child was born, but then he only saw the child a few times a month, and then the problem he had was he only saw the child during the day, no overnights. In the end, he didn't prevail. He was awarded every first, third, and fifth weekends of each month and alternating holidays. That's what we used to call standard visitation. You know, the courts in Tennessee, as in most states, are supposed to be gender neutral in determining custody of a child. The problem is in an initial custody determination, the father's going to be usually at a distinct disadvantage. The statute in Tennessee looks at 15 factors that the court has to weigh before deciding which parent is going to get custody. And one of those factors is which parent has performed most of the parenting responsibility. That's almost always going to be the mother in a situation like that. The other factors include things such as which parent has primarily provided the child with food, clothing, medical care, education, and other necessary care. And that's almost always going to be the mother of a young child. Other factors include the emotional ties that exist. Again, the mother will prevail on that. And probably the most important is who's been the primary caregiver of the child since birth. Again, that's almost always going to be the mother of a young child. That puts dads in that situation at a real disadvantage. Doesn't seem fair, does it? What do you think the solution is in that case? Did you know that you can do some of the legal work in your case yourself and save money on your attorney fees? You know, I've seen cases where attorney fees go up into the tens of thousands of dollars and even higher sometimes, especially custody cases, hotly contested custody cases and cases where there are a lot of assets, a lot of property. Those can cause the attorney fees to run up into the tens of thousands of dollars. But you can save money by doing a lot of the work yourself. You know, we can all get on the internet and look at Zillow to determine the value of certain pieces of property. So if you have a lot of real estate, get on Zillow, determine the value of the property, put it in a spreadsheet, and give that to your lawyer, and that will save your lawyer time, which in turn saves you money. Another thing is Kelley Blue Book. You can get on Kelley Blue Book and put in the VIN number of cars and come up with the value of those cars. And that will save you money, because if you don't do that, your lawyer's going to do it, and he's going to charge you money to do it, money you're going to have to pay.